Hello, everyone. Today's episode is going to be a case update on a lawsuit that I have filed personally against the Macomb County Clerk for violating Second Amendment rights. Hello, everyone. My name is Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC, and today we are looking at why I have filed a lawsuit against the Macomb County Clerk. And this is really an update. We did post a video a couple weeks back that should be on our blog page that introduces the lawsuit, some of the background stuff that we're not going to get into today. Today, we are specifically looking at the words on the page of the lawsuit that I have filed against the Macomb County Clerk. So let's jump right in here. And okay, so what we have here is a standardized form, and I believe it's CC 79. Yep, CC 79. You can Google this form. And what it is the standardized form to file if your clerk has denied you either the application to file for a CPL, or you filed for a CPL and they've denied you, or some other thing, some other nuanceable thing. And that's sort of what we're getting into today. And we're going to look at this. So we have the plaintiff or the appellant. That's me. The appellant is Joseph Radzwion IV. The appellee is the Macomb County Clerk. You have some boxes to check. I have 1C checked. Okay, so 1C says failure of the county clerk to issue or reinstate a license to carry a concealed pistol. This might be a box that you check. Maybe you've had your license revoked in the past and you're appealing, or your time frame has expired. Maybe you've got an expungement done, something like that, and the county clerk has denied your reinstatement of a license, right? Maybe you were suspended for a reason. But for me, it's the first part of that 1C. It's failure of the county clerk to issue. They failed to issue me a license with an exemption box checked on it. Okay, so certificate of mailing. All right, so these next pages are not required to file, but these are the points that I'll be arguing in front of hopefully the judge, and at the very least, in front of the attorney who's representing the county. So you have myself listed as the appellant, the Macomb County Clerk, which is the appellee. We have my lawyer information there, my law firm information. And then also we have co-counsel Dean Greenblatt. I talk a little bit about him in the previous video. You can check that out. And so here's the title: Claim of Appeal on Application for Concealed Pistol License Exemption from Concealed Carry Free Zones. Now, this, I'm going to try and read this the best I can, but I'll probably diverge a little bit. But the appellant is myself. So I'll either say Joseph or myself. And that way it won't get too confusing. This first part is just establishing jurisdiction, right? I already have a CPL issued by the county, and I have a valid employee issued identification card, which is required by law to apply for an exemption in the first place. The facts here are covered in my previous video, but a flyby is that I scheduled an appointment, I showed up, I said what I needed to say. I turned in the paperwork I needed to turn in, and the clerk denied me. I go in depth as to what those documents are and what was said in that meeting in our previous video, if you want to check that out. So the meat of this video, though, will be the law and what the law says as to what the county is supposed to do. Now, there are three things really that the county has done that has violated my rights, and I'm sure they've violated other people's rights in the past going through this, assuming they keep this same sort of mentality, right? So the first one is that they outright denied someone who is legally meets the definition for that exemption. They denied me my exemption. Number two, they denied the request that I made to put in writing why they are denying me, right? And they a sub part of that is that they had a specific time frame to do that, and that time has since passed. That is a violation. Those are two violations tied together. The other violation is that when I then requested what is the appeal process for their denial, they said there is not an appeal process, and they would not give me a form to make such an appeal. So those are three things, right? The outright denial, they didn't write down what they're denying me for, and they're legally required to do so. And then they're also supposed to provide the method for the appeal, and they did not do that either. So those are the three things. Now we're looking at, essentially, that's what's going on here in this first part here under 28.425B, subsection 22. Myself, an applicant for exemption, is required to provide an employee identification card. I did that. Okay. And then within 5 days, the clerk should have issued in writing why they are disqualifying me. Okay. They failed to do that within the 5 days. They failed to do it on the spot when I asked them. I already knew they were going to fail. They told me they weren't going to do it. Okay. And then this next section here, is essentially laying out that the clerk is actually supposed to issue in writing the reasons for the denial. And then later on in the lawsuit here, we have set up where it says they're supposed to provide the actual reasons for the disqualification, right? Like they are supposed to point to what the law says as to why I'm being denied, right? So maybe it was, someone who's applied for a CPL, maybe they have a felony on their record, or, a domestic violence or something. The clerk is supposed to write that down and say, this law prohibits this individual from applying for a CPL. Okay. In my instance, they should have cited whatever. They're not going to be able to, but they're supposed to cite why they're denying me, why I don't meet their statutory qualification, or the statute's definition of court officer. Okay. So under MCL 28.425B13, the clerk is required to inform myself in writing the reasons for the denial. Again, they didn't do that. All right, let's move on here. The clerk is required to provide a statement for each. Okay, I said that, and they failed to do that. Under MCL 28, let's see, the source, I talked about that. They're supposed to cite the law. They didn't do that. And the appellee is, the clerk is required to provide the contact information for the source of the record, and they didn't do that. Okay. And that's essentially one of the big three things that they violated, right? They failed to put it in writing. This is the other part, right? And starting in number 14, the appellant, being myself, has a right to appeal their denial. And upon me requesting for that information, they failed to provide it. All right, this is now getting into the section that specifically talks about what the law says for the officer of the court exemption. All right. So under MCL 28.4250, individuals who qualify under one of the subsections from 5A through J are eligible to apply for and be exempt from the concealed carry free zones outlined in MCL 42501 and 2. So an individual who's the law says an individual who's licensed under this act and who is a court officer is exempt. All right. The clerk has failed to recognize myself as a court officer. The law is actually very clear on this. MCL 600.901 says that members of the State Bar of Michigan are officers of the court of this state and have the exclusive right to designate themselves as attorneys, attorneys and counselors, attorneys at law, or lawyers. MCL 600.901. Okay, so right there, because I am a member of the State Bar of Michigan, the state of Michigan issues attorneys their licenses. I, by default, am considered an officer of the court. All right. and the clerk fails to recognize MCL 600.901 as designating me as an officer of the court. The next section here really talks about, I put in there a case, grievance administration versus Feiger, and this comes from the Michigan Supreme Court in 2006, essentially saying that the law imposes special duties on lawyers to, that they're more than mere advocates who happen to carry out their duties in a courtroom environment, right? We're not only lawyers in the courtroom, we are officers of the court. What does that mean? Officers of the court can go outside of the court and perform their duties, right? In this exclusive role, the court or the Supreme Court held that the lawyers have special responsibilities in relations with other officers of the court, right? So other duties may be being candid with, or showing candor to the court, being respectful to other attorneys, being truthful and honest, providing information that's required under the court rules, honoring the court system as a whole, right? And making sure that you're being a professional, not just inside the courtroom, but also outside the courtroom. All right. The Michigan Supreme Court also found that a lawyer is an officer of the court with the special authority to act on behalf of the court to compel private citizens to stop their daily routines and be summoned before the court before official court business. Furthermore, the court found that such powers extend outside the courtroom. All right. And this is important too, because the relation that I'm trying to make here is that under this next point here, under MCR, that's Michigan Court Rules 2.104, an attorney is granted the same powers as a sheriff, a sheriff's deputy, a bailiff, a process server, right? To act on behalf of the court. We are considered agents of the court. This next point here, right, is talking about how we are authorized to designate ourselves as attorneys or attorneys at law to practice law in the state of Michigan. And, the point is that we have the same authority to take a summons and complaint, right? That's how a lawsuit is started. We have a whole video segment on how to read a summons and complaint. You can look for that. But essentially, attorneys have the ability to take a lawsuit and walk up to someone at their house, knock on their door and say, here's your lawsuit. You've been served. We'll see you in court, right? The same thing. The sheriff can do that. The deputy sheriff, a bailiff that's acting on behalf of their court of jurisdiction, right? So the attorney has the same capacity to walk up to a private citizen and say, you're going to stop everything that you're doing in life. The judge wants to see you. Okay, that's how you can think of it. And essentially the end of this lawsuit here, and what this says 26 through 30, is that at all times, Joseph, myself, is by law an officer of the court defined by statute and case law. At all times, I am recognized by the Michigan State Bar as an officer of the court. At all times, I hold the authority under my license to act on behalf of and with the authority of the court to summons people to court. At all times, I have the authority as an officer of the court, which this authority applies both inside the courtroom and outside the courthouse. All right. At all times, I qualified for an exemption under MCL 28.42505J, the definition of court officer. And then just at the end here, it essentially just says that I'm requesting that the Macomb County Clerk be ordered by the court to grant myself, the appellant, an exemption under the law as required by law, because by definition, an attorney meets the definition of court officer, right? That is what we are arguing here in this suit. Now, something that I just came to mind that I forgot to tell you, this suit, the most important part about filing a lawsuit, and not just with this one, is being timely, making sure that you don't miss the statute of limitations, and making sure you get notice filed for the appropriate parties on time. So right here it says this this appeal must be filed within 21 days of entry of the decision being appealed. So I had to file this suit within 21 days of my conversation with the clerk. And again, you can see that video that I posted, me describing that interaction. But that is something that you need to keep in mind if you're filing suit, whether it's an appeal for a CPL or not, is to be timely. All right, so I hope this video finds you well. If you do like it, please share, comment, like, subscribe. I don't like having to say that, but I do anyway so that this type of information can get out there. Remember, we are here to protect you when you need it most, and we will fight for your freedom, whether it's appealing a CPL denial or any other sort of firearms charge, firearms rights. We are here to protect your rights. Please do not hesitate to contact us, and we will see you in the next video. Thanks for watching, everyone.